welcome, everyone. I'm Lee Merriweather, and with me is Todd Orston. Todd and I are partners at the law firm of Merriweather & Tharp, and you're listening to Merriweather & Tharp Radio on the new Talk 106.7. Here you will learn about divorce, family law, tips on how to save your marriage if it's in the middle of a crisis, and even tips on how to take your marriage to the next level. If you want to learn more about us, you can always call or visit us online at AtlantaDivorceTeam.com.
Well done.
Oh, thank you.
I mean, seriously,
I've been practicing.
Yeah, yes, you have.
Thankfully.
Well, hello again.
Are we ready to dig in?
We are. What are we talking about today?
Today, we're going to talk about DIY divorce.
Okay.
You can't get it at Home Depot.
No. I've done a couple of DIY things at my house, and
how'd they turn out?
My wife wished I didn't. But with divorce, it is possible. I talk to people all the time, and I mean, I know you do also. And just 2 days ago, I was on the phone with somebody, and they were talking about the possibility of doing it themselves, handling their own divorce. Absolutely. Can you? Yes. Is there a requirement that you hire an attorney? No. Is it potentially better if you do? Yeah. I mean, because one of the things we're going to go into throughout the show is, you know, a lot of people handle it and they get it done and they do it right.
Mm-hmm.
What they don't hear about, and what many people don't hear about, is all the people who try to do it on their own and they make big mistakes.
Yes.
And these kinds of mistakes can carry with you, not just for days or weeks or even months, but for years. So
sometimes even a lifetime.
Absolutely.
So we're going to break down some of the pros and cons of doing a divorce yourself. We're going to talk about the ideal situations where it would be, I mean, I think there's little chance of you really messing things up with doing it yourself. And then we're going to give some cautionary tales where people, very intelligent people, this is not something that's limited to people that can't afford a lawyer. There's a lot of people out there that think that bringing lawyers in complicates the process. And sometimes it's not that the lawyers complicate the process. It's just that the process is more complicated than they understand. And we're going to talk about the consequences of not doing it right and give some real life examples of what happens when you don't do it, when you try to do it yourself and do it the wrong way. I mean, in some cases, it's $1 million impact. And we'll talk about that. And, but first off, we probably want to say we don't have any, like, I don't want to, when we talk about the cons of DIY divorce, you know, we do make money when people hire us. So this isn't something where we're saying, hey, don't do it because you need to hire a lawyer. We're not saying that at all. What we are saying is there's cautionary tales. And I mean, you could just look at our website. We have 5,000 pages of content on our website that, I mean, you could almost do your divorce yourself if you read it. And then we've got our podcasts, our past radio shows. We convert to a podcast. We broadcast in iTunes and Stitcher and on our website even, put the transcript of the show on our website. And you could many people could just listen to all the shows, or at least the ones that are applicable to them, and do an okay job. But if you think about it, we have I think 91 episodes up there now, and if you were to listen to all 91,
I'm sorry. Call in and we'll talk about some other hobbies.
But I mean, that's 91 hours of content that you have to. So how much is your time worth?
Yeah.
Spending that kind of time. So,
well, there's the way that we look at it. I was going to say the way I look at it, but the way that we look at it is there's a certain amount of basic information that anybody can get by going online and doing some searching. We're not in the business of playing games of hide the ball, of taking that information, not disclosing it, and basically saying the only way you get it is if you come in and pay us. We actually want our clients to be educated.
Yes.
Because if they're educated, then it makes it easier for us. We can then talk to them, explain things to them. They've already looked at our website. I mean, when we take calls for prospective clients, almost, without fail, I will say, have you gone to our website? Whether you hire us or not, go to our website. There is a tremendous amount of information for free there. There's no obligation. You don't have to sign up. You don't have to do. Just go there, read, educate yourself. Okay, we have condensed and consolidated all of that information into basically a format that's easy to access, easy to get information out of. And we do that for a number of reasons. And the second reason, other than wanting people to be educated, is because we know that while this is not, you hit on this, divorce is not complex, but it can be complicated.
Right.
There are a lot of ins and outs. We're not talking about brain surgery here, but there are a lot of things that are complicated. And like I said before, if you make a mistake, if you don't educate yourself, maybe even hire someone to help you, you make a mistake and it can carry with you for years.
Yeah, so I'm going to give a few examples of where we've seen that happen. So I had a case where I was handling now it wasn't a DOI divorce, but the client had done his own prenup with his wife. And the way it read, the opposing counsel took what he put in there. It wasn't the best language. And the opposing counsel was arguing that our client had committed to pay his client $400,000 in non-modifiable, non-bankruptable alimony to his client. And so he only made $75,000 a year. So suddenly he has $400,000 liability that he can't.
I'm not a mathematician, but that doesn't work.
No, so he couldn't even write it off or anything like that. So had he talked to a lawyer, it would have different language. Now, I will say there was a silver lining there in that we were able to win. But I mean, he went up to the Supreme Court of Georgia, but he spent $25,000, $30,000 in legal fees trying to avoid $1,500 and having a prenup put together.
And by the way, I mean, I'm glad you talk about the positive outcome and the silver lining. Okay. Yeah. A lot of situations, and I would even go so far as to say the majority of situations, don't have that happy ending. Mm-hmm. Normally, if you enter into a contract, whether that's a prenuptial agreement or a divorce agreement, if you are an adult, you're of sound mind, and you sign off on that agreement, you're locked in.
Yeah.
And getting out of it or trying to change it might actually be impossible. Okay, so yes, that's great, and we did help that client. But I want people to really understand that if you do this on your own, you sign off on everything, that may be the exception to the rule.
Yeah, and it's funny you mentioned that. So I had another person that came in for a consultation.
Now you're just bragging. Right? It's just, I helped another person.
No, and this one was the one where there wasn't a silver lining.
Yeah.
So he had represented a smart guy. He made pretty good money. I can't remember the exact number, but it was over $100,000. Made pretty good money. And he's like, well, I can do the divorce myself. And so he entered into an agreement that basically he unknowingly committed to $1 million in alimony over the lifetime of the payments that he couldn't modify. And he didn't know it. He just wasn't paying attention. And there was issues about whether it was even tax deductible. And I couldn't do anything. He was locked in place. That was an example of that he had entered a contract that could not be changed. You couldn't. And here's the important thing, what I think everybody needs to know, is that when you enter this agreement, it becomes a court order. And some of the aspects of that court order cannot be changed. You cannot bankrupt on them. And if you don't pay them, you go to jail, because this is a situation of almost, some people argue this is almost like debtor's prison. If you don't make your alimony payment, the court has an obligation to enforce its orders, and the court could order you to go to jail until you make your alimony payment. So, I mean, this is very serious.
Yeah, I mean, with contempt, obviously, if it's a situation where you agree to $1 million and you make far, 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 far less than that, more than likely a contempt would be brought and the court would recognize you don't have the ability and therefore you are not in willful contempt, but you still owe the money.
Right.
So what has basically happened, if you agreed even to that kind of amount and the judge says, okay, fine, you can't pay $10,000 a month or whatever crazy number you agreed to, but lowers it to $2,500, but you're paying for the rest of your life. Mm-hmm. We're moving a little bit away from the basic point, which is talk to an attorney at the very least. And we're going to go into this later on. There are options.
Besides that are
just retaining.
yes.
Go and speak to an attorney at the very least. Do a consultation. We do something called consultations or coaching. There are different options. Explore those options as quickly as you should be going to a website to educate yourself. Make a phone call. Pick up the phone. Talk to an attorney. Find one that you like and see what your options are.
So up next, we're going to get into the situations where it's probably you're pretty safe with a DIY divorce. We're going to get into situations where you really want to consult with an attorney. We're going to get into situations with what DIY divorce websites, what they're missing, what they
DIY is DOI.
DIY. What they can't do for you, what information you will be missing by using them rather than consulting with an attorney. And we're going to get into some more cautionary tales up next. Welcome, everyone. I'm Lee Merriweather, and with me is Todd Orston. Todd and I are partners at the law firm of Merriweather and Tharp, and you're listening to Merriweather and Tharp Radio on the new Talk 106.7. If you want to read more about us, you can always call or visit us online at AtlantaDivorceTeam.com. So, all right, we have been talking about DIY divorce, and we believe in helping people. That's why we do this show. That's why we built a huge website. But we want to talk about the challenges of doing your divorce by yourself and what sort of problems you can get into and that sort of thing. And that's what we've been talking about. And I think before we move on, we actually have 7 things that you really should consider before trying to do it all yourself. But before we get there, let's give 2 more cautionary things about a DIY divorce website.
Yeah, I mean, we have talked a lot about our website. We have a tremendous amount of information. And we're not sitting here saying we are the only website out there, that we're the only source for information about divorce. We're the best. But you have to be careful. Mm-hmm. And that goes even for our website, because we put information out there, but it's not just what content we put out there. It's also how it's interpreted. And also, there are a lot of things that need to be considered. We've put information out there, but what you think applies to you may not apply, or you read one part, but you haven't read 3 other parts that apply. And so you may unfortunately think you understand something, but you don't.
Yeah.
Okay. So there are definitely weaknesses in just relying on your own search, online search or otherwise. Things like a lot of those sites, even our website, we can't and don't give out advice. Mm-hmm. Right? I mean, we have content.
We talk about the law.
That's right.
But we can't say how that law applies to your specific situation.
And no one can. And if you go to a website and it appears like they are giving you some level of legal advice, click over to the next website because they can't. All right. And they shouldn't. And we don't. So
we break down the things that a court consider when deciding custody. And basically, we try to explain the law in a way that's easily understood. Yeah. Because sometimes we have to read the statutes 4 and 5 times.
Absolutely.
And even then, the judges misread it.
And laws change and new laws come out. And so, in
fact, we're having to rewrite parts of our website because of some recent law changes.
That's right. That's right. We're constantly making changes.
Yeah.
And then sort of like what we were doing, in the last segment, talking about experiences. Mm-hmm. You're not going to get that from a website.
Yeah. So, I mean, when you come and talk to a lawyer like at our firm, a lot of them have we all have a lot of experience. Now, you may talk to someone that may have been out for 5 years, but if they're working inside a firm where cumulatively there's well over 200 years of experience. And so what you do is you hear, okay, that sounds great in theory, but did you think about X, Y, and Z? And usually people go, I didn't think about that, because what we see, because we do modification cases too, we have seen where certain settlement provisions or custody arrangements really can end up in utter failure, and it's not in the children's best interest. That leads me into another thing that I just remembered is that, we've seen courts where someone puts together a settlement agreement that both parties agree to it, and they walk in and the judge says, I'm not accepting this. I'm not accepting this. It's not up to code. It's missing this. I can't tell you everything it's missing, but I can tell you that without these items, I can't grant your divorce. So,
and the court's job is not to educate you. Sometimes judges will say, "Yep, I'm not accepting this." They're not going to tell you what they will accept.
right.
If things are missing, they're not going to tell you, oh, "This is what you need to do: A, B, C, D," and then you can go fix it, come back. Sometimes they just say, "You know what? You're not prepared, and I'm rejecting this agreement. Come back when you're done." A good example of that is custody, joint physical custody. There are some courts and some judges that even if parties agree, they do not agree. I mean, meaning the court will not agree, will not consent, and sign off on an order that allows for a joint physical custody arrangement.
Yeah.
And had you gone and spoken to an attorney, you might have come up with some strategies. You might have, first of all, educated yourself and known the judge, known what was possible or not possible, and then tweaked the agreement in some way to make it more palatable, more acceptable to the court.
Yep. All right. So let's talk about what are the situations where it might be best for someone to use a DIY website.
All right. So I'm going to start with the first one, no children. Okay. And the finances have always been kept separate.
Okay.
Right? And sometimes, and grouping it into the very simplistic kind of case where people have kept it separate, or if you don't have a lot of assets, you may have a joint account or joint accounts, but there's just not a lot of assets there. You see that a lot in short-term marriages, especially young people getting married, and they haven't built up that nest egg. There's not a lot of...
They're living in an apartment. They haven't bought a house.
Yeah, so they don't own a house that has to be divided. They each have their own car. There are no children, no pets that they're going to fight over who gets custody. Then not only is it possible, but we've talked people out of hiring us because it's like, look, you don't need to pay a retainer to us. Maybe do a consultation to educate yourself.
Yeah.
Or draft the documents, come in, we'll look at it in a consult and make sure that it meets all the requirements. But otherwise, you can do it yourself.
Yeah, and we've even had situations where like they called us and we said, well, I'm not sure that you could probably do a lot of this on your own. And what they did is they came in, great, but I need a place to get started. I've read your website, but just give me help me get me started. So they came in. We did a lot of the initial paperwork in that initial consultation because it was so simple we could. And then they walked out with all the documents they needed to get through the whole process. So we've even done that before.
Yeah. But if we're talking about a from scratch, do it yourself, you're not doing a consultation, we're talking about simple.
Yeah, it's got to be simple.
If it's not simple, if there are children, if there are retirement accounts that need to be divided, anything like that, if alimony is a topic of discussion, then can you do it yourself? Yes. There's a lot more opportunity for long-term harm.
And what's interesting is, so there are websites that charge for forms, but I know here in Georgia, most of the counties have sample forms on their website, so you don't even have to pay for the forms.
That's
you
right.
can fill it out because the DIY websites where you pay, they can't give you legal advice as you fill it out. So,
and some of them say that advice is available, and you can come in and you can pay a tremendous amount of money for documents that are free on
online.
Other state or county websites. The bottom line is, if you're going to pay money, why go to a national firm that basically is selling documents rather than a local Georgia, if we're talking about Georgia, a local Georgia attorney?
Yeah.
And whether you want to retain them or do a consult, then you're getting good advice and good help from somebody who knows the specific laws of your state.
And I will say, so a lot of people may not think about this, but it is so worth it to take your time, I think, to at least meet with a local lawyer in your county, because here's the thing: if missing work, if you can't afford to take time off work, because a lot of these courts you've got to go to court to finalize your divorce. If you can't afford to miss time away from work, what you don't want to do is go to the courthouse 3, 4, 5 times and miss 5 days of work because each time you go, the judge is like, well, this form isn't right, and this form isn't right, and this form isn't right. And we've actually gotten hired by people that said, I couldn't afford to take any more days off and get it wrong. And so they hired us. We cleaned up the paperwork. And
I've seen it. Yeah. I've gone to court where I've taken finals go to court one day to take a final. People stand up. They're not prepared. The judge sends them away. Just so happens I'm there again, let's say in a week or 2 weeks or a month, and I'm there to take a final in a different case, and the court says, oh, Smith case.
Yeah.
They stand up, and it's like, well, what do you have? Nope. You missed it again. Thank you very much. Come back. Come back when you're ready.
Yep.
So it does happen.
I think we've already led in. So the first tip is, you don't always have to retain a lawyer to get good legal advice. So that's our first tip, and we've kind of talked about that a lot. But I think I call it DIY MH.
God bless you. I mean, we got to stop at these.
Don't like my acronyms?
Mental health?
No. Do it yourself with minimal help.
Oh, okay. I'll make some notes.
I guess maybe I need more than minimal help. No, and that's what we do. We DIY MH. We do coaching sessions, and there's lawyers out there that do it. It's been permitted in many jurisdictions where pro se litigants, they can't afford to hire a lawyer full time, but they can't afford to get ongoing consultation.
And that just means going in for an hour, hour and a half, whatever it is.
Just pay the hourly rate.
And you're going to sit with the attorney as if you were the client, and you're going to talk about options. You're going to talk strategy, and they're going to help you, or like we do, we'll even give you some forms. We'll help you fill it out, whatever help you need to do it yourself properly. We're going to give that help.
And we've even had cases where the client couldn't afford us, but they couldn't afford to not talk to a lawyer. They met with us all along the way. The other side had a lawyer. They went to court. They tried the case, and they won.
Yep.
Because, and I think the reason they won is because they did take the time to do consulting with an attorney. Hey, up next, we're going to get into 6 more things that you should be considering before doing a DIY divorce. Welcome, everyone. I'm Lee Merriweather, and with me is Todd Orston. Todd and I are partners at the law firm of Merriweather and Tharp, and you're listening to Merriweather and Tharp Radio on the new Talk 106.7. If you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com.
You can check us out.
Take us out. No. All right, so we've been talking about DIY divorce, and we've talked about some cautionary tales, things that can go wrong quickly if you're doing it yourself without talking to a lawyer. But, that doesn't change the fact that sometimes people have limited resources and can't afford an attorney, at least to retain them full time. So we talked about DIY MH, do it yourself with minimal help. I know you love that.
I love it. I'm going to make a T-shirt.
Make a T-shirt. All right, so...
But before we move on, because you had talked about going on to tip 2, and before you do, I want to make one more statement about what we were talking about in the last segment, and that's before you sign off on an agreement, okay, my advice, our advice, is going to be have it reviewed by an attorney.
Yes.
All right? Even if you're doing it on your own, I mean, unless you were just unwilling or unable to have an attorney, just do a quick review. Then have it reviewed, or at the very least, build into that agreement the ability to walk away and basically pull out of that agreement.
Right.
In mediation, depending on if certain factors are present, parties will walk away and have basically a period of a few days.
If they're not represented by a lawyer.
Correct. To walk away, basically to pull out of an agreement reached at mediation.
Right.
If you don't do it within that time period, you are bound. That goes to what we were talking about before. Build into an agreement that you have 1, 2, 3, 4, 5 days to basically walk away, to have it reviewed by an attorney, and if necessary, basically withdraw your consent. Yeah.
And but probably should mention this one other thing that, sometimes people are like, well, we can just, you may get, start over again. You may have situations where the husband or the wife, depends, but let's say the husband comes to the wife and says, I've hired a lawyer. We want to do this uncontested. They've drafted the paperwork. They can represent both of us. We've heard that comment made, but under every state that I'm aware of in the United States, is a lawyer can only represent one party. So as soon as you hear that a lawyer can represent both of you, that's not true. And so if whoever hired the lawyer, that's their client. And so if you get that settlement agreement, go have a lawyer review it.
And be very clear. If you think that the attorney is representing both of you and you're sitting in a meeting, at some point, don't be shy and say, I just need to be clear. Who do you represent? Mm-hmm. Are you representing me? So the advice I'm getting or that I think I'm getting from you, are you giving me advice as my legal counsel? That attorney should, at that point, either say one of two things. Yes, I'm your attorney, and ma'am or sir, I'm not your attorney.
Right.
Or no, actually, I represent your husband or wife, and I can't give you legal advice. If they say, no, I'm representing both of you, understand that what's just happened, forget about being wrong. It's building into that agreement the ability to have it set aside. Mm-hmm. Because if the other party or one of the parties then says, wait, hold on one second, I was getting advice. I was told that they represented both of us.
Right.
But that's a conflict. Then you're building in this argument that, no, judge, I thought I was being represented, that it was my attorney. I want that agreement set aside. So all that effort, all that work for nothing because the agreement gets thrown out.
Yes. So, all right, let's go to tip number 2.
Yep.
All right. So the question you need to ask yourself when you're working with a settlement agreement is, are you answering the who, what, when, where, how, and to what extent questions? And so anytime you have an obligation inside of a settlement agreement, you need to have in there that, who's doing what, when, where, how, and to what extent. I know that sounds, you probably learned that in grade school, but it is important. So every time you've got something critical in there, you need to look at each paragraph of the settlement agreement to see if that is stated. So a good example is you'll see things where it'll say like, well, so-and-so is going to close out their credit card and remove so-and-so's name from this credit card account. And that's all it says. There's no deadline. And so you need deadlines. It says within 30 days, they're going to remove this person. And to the extent that they don't, and there a liability occurs, that they're going to be indemnified. So if the husband didn't pay a credit card that the wife's name was on, and she gets a call from the creditor, that she can turn around and go after him for not following through on it.
And here, let me break down just a little bit more. Let's even have a situation where, let's say there's a big credit card balance in the parties' joint names, and let's say the husband is going to be responsible for paying that big balance off. Mm-hmm. And 2 years later, 3 years later, you're going to buy a car or you're going to buy a house, and they look at your credit and it's like, well, you still owe $30,000 on this credit card. And you're like, no, that's my ex-husband. Mm-hmm. They're going to look at you and say, no, it's on your credit.
Right.
And all you can do is then try to enforce the agreement. But if all it says is that he's responsible, then
he could pay it off.
If he's paying the
30 years to pay it off.
If he's making the monthly payments, then he is in compliance with the terms of the agreement. So you need to think not just superficially. You need to dig a little bit deeper and make sure that there's some language in there that is truly going to protect you.
Yeah, that's an excellent point, because if it just says he's responsible for it and he pays the minimum and it doesn't ding her credit in this
then there's
sense,
nothing you can do.
There's nothing she can do. She cannot remove that from her credit. I will say one thing she can do is, and this is outside, but she can do, so she has to go to some place that does manual underwriting, meaning that they look beyond the four corners of your credit score. Mm-hmm. And, one of the things that has driven me to make sure that we do a good job as a divorce firm is what happened to my wife. And so she had poor representation in hers, and it dealt with credit cards, and she wasn't given good advice. And as a result, we had to do a lot of manual underwriting for a few years of our marriage. And it's not her fault at all. But because there was things on her credit that in the settlement agreement, it said he was responsible for, but there was no details on what that meant.
Yep. So we've seen a lot of people get into trouble. And when I say trouble, it's just it has a long-term effect because they're sitting there waiting for it to be paid off.
And so another good example of that, it has to do with the children. Some people will just say, they'll just keep this big vague thing where like, all right, well, mom and dad are going to split custody. Thankfully, the new parenting plans that have come out make that more difficult, but you still need some level of detail in the parenting plan. Who's responsible for taking care of what part of the children's daily needs? And
how about decision-making authority?
Decision-making authority.
I mean, and again, you're right. The new parenting plan orders, this goes back to where courts will oftentimes reject an agreement if it doesn't have all the required terms and deal with all the required issues. But final decision-making authority, we've seen, and courts have seen many agreements where it's the parties are going to mutually agree on major issues relating to the children.
Right.
And that's it. Well, that means that there's no tie-breaking method, which means that if you hit an impasse, there is no fixing it. There's no getting beyond that impasse other than one of you is going to end up filing something with the court.
To get a modification.
That's right.
To fix it. So, so make sure you're addressing all those questions in every key paragraph of your agreement. All right, the next thing to consider is what is modifiable and what is not modifiable. And what I mean by that is when you go to court and when it's done, most of the time it's called, if you can't revisit that in a later court action most of the time, in most civil proceedings and criminal proceedings too, it's called res judicata. It's already been decided. So in divorce world, however, there are two exceptions to that. One is support and the other is child custody. Those two things are modifiable.
Because life happens.
Right.
Right.
But there are times when you can waive your ability to modify child support and your ability to modify alimony.
Don't do it.
Yeah, don't.
I'm sorry.
Don't waive
do it. No.
So there's times when you can even waive those two things. Usually, child custody, the courts always have the ability to come back and modify that.
You can't do something that's non-modifiable.
Yeah,
if suddenly you have an addiction, the court's not going to be like, well, I'm sorry, I know wife is doing crack now, but it's non-modifiable, so she gets the kids.
Well, I can't waive custody. Yeah. So, but what isn't modifiable is a division of your assets and your liabilities. So going back to what the example you gave earlier, where the person, it just said that the husband could make the credit card payments or is responsible for them, and that was it. You can't change that. You can't go back to court and say, hey, can we make this happen in 30 days? No, you're stuck. So you just can't change it. And
so the way that we handle that is dealing with, like what you were saying, the who, what, where, when, why, all of those things. We need to understand what the debt is. You need to understand who's going to be responsible, whose name is it in, who's responsible, when is it going to be paid, how's it going to be paid, what happens if it's not paid by a certain deadline.
Right.
If you put all those things in, then it's enforceable. Then you have a plan and you're done, and you protect yourself.
Yep. Hey, and up next, we're going to hit the last few tips of what you need to take into consideration. Welcome back, everyone. I'm Lee Merriweather, and with me is Todd Orson. Todd and I are partners at the law firm of Merriweather and Tharp, and you're listening to Merriweather and Tharp Radio on the new Talk 106.7. If you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com. Well, today we're talking about DIY divorce, and we've been talking about all the things that you need to keep in mind if you're considering doing this. We've talked about one scenario where it makes a lot of sense to do it yourself, but talked about all the other scenarios where it doesn't. And we've got a few more tips that we need to hit in this last segment. They're pretty straightforward. That's why we saved them for the last segment. So we're on tip number 4 now, and that's that these agreements are enforceable by contempt. And we alluded to that in the first segment of the show. But if you don't comply with these provisions, if you enter in something where you say, I'm going to pay $5,000 a month, and you're not paying attention, or you commit to, when you add up the whole settlement agreement, it equals $5,000, but you only make $4,000 a month, if that's your take home, well, the court can say that's what you agreed to. You need to pay it, and then you can be held in contempt of court.
There's no coming back and saying, Judge, I don't know what I was thinking.
Yeah.
I didn't mean to agree to that. At that point, the court's going to say, there's nothing. Actually, the court could say, there's nothing I can do.
Yeah.
Because the grounds for modification are that there's been a material change of circumstance. If you made $60,000 and agreed to pay $5,000 per month, $60,000,
right,
in alimony, and you then 2 years later go back to court and say, I can't do that, and at that time you're making $60,000 or more, then there hasn't been a material change of circumstance to warrant a modification. So you have to be very, very careful. And contempt is if you had the ability to do it and you chose not to.
Mm-hmm.
It might have been difficult. It may have, financially put some pressure on you, but you could have tried to borrow. You could have used credit cards. You could have not gone on 1 or 2 trips. Okay. Then you could be held in contempt.
Mm-hmm.
And that could include, sort of like what you were talking about earlier, jail.
Yeah. And nobody wants to go to jail.
No.
All right. So tip number 5, divorce agreements have exclusions in bankruptcy court. So a lot of people don't realize this, but when you make a financial commitment in a divorce decree, that can be something that you cannot bankrupt on. So perhaps you bankrupt, like you say, I've got these credit cards and they're jointly titled in my wife's name, and I'm going to just get out of under filing them, but then they come after her afterwards. She can turn around and bring you in for a contempt action, and you're still going to have to pay them because you agreed to under the divorce decree, and the court can say, hey, this falls into an exemption under the bankruptcy court rules.
Well, because at that point, it's not just purely a debt to a third-party creditor.
Right.
At that point, it's a contractual obligation. You voluntarily contracted to take on responsibility for that debt.
Yeah, in a domestic setting.
In a domestic setting.
Yeah, because
correct.
you can bankrupt
Right.
on most contracts.
Correct.
But there are exceptions. So like student loans is an exception, and domestic cases is an exception.
Yep.
So that's something that's critical that people need to keep in mind of. All right, number 6, third parties don't have to follow your agreement. And we've, again, have alluded to that, but what we mean by that is, because I've heard people call up and say, well, my divorce decree says that my husband's responsible for the credit card, but he quit paying it 6 months ago and they're coming after me. I don't have to pay it, do I? And unfortunately, we have to explain, yeah, because you entered an agreement to be jointly responsible for this credit card with the credit card company. The credit card company was not part of your agreement with your husband. So you're still obligated to pay the bill, even though he's not paying it. Now you can bring him into court for contempt.
Yeah, there's something called indemnification language that is going to be included in all of our agreements, but in most agreements. And what that means is that you have the ability to then, in essence, look to your ex-spouse and say, you are responsible for this. And basically it means if a third party comes after me,
yeah,
I can look to my former spouse and you need to indemnify me. You need to make me whole.
Mm-hmm.
Okay. And so that is the case. But it's a huge headache. And it's a headache that you can, again, tying into the overall theme of the show, that you can potentially avoid if you do things right the first time.
Yeah. And, it's another example is dealing with a house, because that can be a really big one.
Yep.
And that was another thing that happened to my wife, too, that he was going to pay it. And here's the other thing, that we probably need to point this out, that you can see people that while they're married, they appear responsible, they're paying the bills, but divorce impacts people differently. And there have been situations where the divorce was so emotionally devastating, at least on a short-term basis, to one of the parties that they just quit paying everything. And they're like, oh, I don't understand. They were so responsible while we were married, and now they're not paying, and I relied on their past performance in this situation. That's why you can't do that. That's why it's so important that you have the right language in your agreement. All right, number 7. I wanted to spend a little time on number 7 because I think there's a lot of little nuances here, and there's things that people need to understand. All right. So there may actually be resources to hire an attorney in your situation. Now, we've seen situations where one spouse controls all the money, or at least the vast majority of it. You may have 2 working spouses, but one makes $20,000 a year and the other makes $200,000 a year, and the breadwinning spouse, and it could be the husband or the wife, because we've seen those scenarios, says, well, you need to use your 20 to pay for a lawyer. But meanwhile, this other person has all this money. And so the first reaction is, I can't afford a lawyer because you're not even giving me money for child support, or you're not giving me money to pay my car payment or whatnot, so I can't afford a lawyer. Well, in Georgia, at least, and I know there's a lot of states out there that have a similar code section. How judges apply those code sections is another story, but there are code sections out there that says, hey, look, if we want the parties to be on an even playing field. And so the court can order the higher income earner to pay some or all of the attorney's fees of the other party to equal it out. And so I think that's something that's really important that people need to understand.
Yeah, it's discretionary. It's going to be up to a court, and typically what we're talking about is an award of legal fees. It's going to come at one of two times, either as interim fees, meaning it's during the pendency of the case before it's finalized. You look to the court and say, hey, my client, we would be saying our client needs financial assistance, cannot afford an attorney without the financial help of the other spouse, and then the court can give those temporary or interim fees. Or you have to pay everything yourself, and at the end you can ask the court to award some fees. But again, that's not helping you throughout the pendency of the case.
Right.
But again, it's discretionary.
Yeah. And we see these situations where there's one party's using these bullying tactics where they're saying, hey, look, if you don't sign this agreement, I'm taking the kids from you. Or I'm going to make you pay alimony for the rest of your life if you don't sign my agreement. So, I mean, on both sides, I've seen both parties use the kids, and which is horrible at another, all kinds of levels. But don't be frightened if a spouse says, if you don't sign this agreement, I'm taking your kids from you, because they don't have that, the court. When you get into divorce court, the judge is the one who decides who's the kids are going with. So don't let one parent try to bully you into signing an agreement that you may feel because you feel like you can't afford a lawyer. And, at the bottom, I want to circle back around to our, one of our first things was that, look, just borrow, $200-300 from a friend and go have a consultation to find out what your rights are.
Well, and this goes back to what we said. It's not always all or nothing.
Yeah.
I mean, I get it. Hiring an attorney is a lot of money. I talk to people every single day, and we talk about what they are capable of doing. And there are people who call up and, good for them. It's not even an issue. I want to hire you. I have the money. I'm going to hire you. Yeah. Great. Then there are many, many, many people who call us, and we will spend a significant amount of time talking with them. And we'll talk pricing, and they'll be like, I can't do that. I wish that I could, but I can't.
Yep.
Doesn't mean that the conversation ends. All right. That's when we start talking about doing a one for, coaching session,
right?
Or consultation,
an ongoing coaching session,
ongoing coaching, which is basically like doing a consult, but then you have the ability to follow up.
Yeah.
And
hey, I've got a hearing coming up. What do I need to do to prepare?
Correct.
And what evidence can I get into court? And we can do that. We've had successfully.
And different attorneys offer different things.
Yeah.
It just really comes down to asking the right questions and figuring out what your ability is in terms of payment and what is offered by the attorneys.
So as a quick wrap up, because we're just about out of time, here's the 7 quick tips. If you don't have to retain a lawyer to obtain good legal advice. 2, are you answering the who, what, when, where, how, and to what extent questions? 3, understand what is modifiable and what is not. 4, these agreements are enforceable by contempt. 5, divorce agreements have exclusions in bankruptcy. 6, third parties don't have to follow your agreement. And 7, there may be resources to hire an attorney. So those are the 7 things you need to consider when getting a divorce. And hey, everyone, thanks so much for listening. If you want to read more about us, you can always go to thelandofdivorceteam.com. And we actually, if you've missed part of this or want to listen to it again, we put the shows up on our website. Thanks again.